Welcome, and thank you for being here. The right to a trial by jury is an important part of our country's history. Interestingly, the founders mentioned jury service 3 times in the United States Constitution as both a right and a responsibility. Serving on a jury gives an ordinary citizen a direct hand in the administration of justice. Jury service connects people from all walks of life, regardless of race, class, disability, creed, or ethnicity. Your jury service is invaluable. This trial is important to all those involved. After all, if both sides agreed, you would not need to be here. Our basic jury trial process is essentially the same now as it has been for over 2 centuries. You, the juror, are the backbone of American justice. Jury trials cannot happen without you. We depend on your willingness to listen, your attention to detail, and your sense of fairness. First, let's review the people involved in a trial. The trial is presided over by a judge, whose job it is to ensure that the trial proceeds fairly, efficiently, and in accordance with Nebraska law. He or she will rule on all objections and other legal questions that may arise during the course of a trial. Most likely, litigants on both sides will have an attorney who will present the evidence and make arguments on their behalf. The attorneys may tell very different stories throughout the trial, each from their own client's perspective. You may also see an individual who decides not to hire an attorney and will instead represent him or herself. This individual is called a self-represented litigant and must follow the same rules that the attorneys follow. A court reporter documents everything that is said during the trial. An interpreter may also be present. At some trials, you may see Supreme Court credentialed media representatives who are allowed to use court-approved electronic devices to take notes. Reporters are prohibited from taking photos or video of the jury. Now, let's review the types of trials: civil and criminal. Civil trials generally involve disputes between people or businesses seeking money for damages or for personal injuries. The litigant who sues is called the plaintiff, and the litigant being sued is called the defendant. In a criminal trial, the government is represented by a prosecutor. The defendant is a person accused of committing a crime that may be harmful to society. Crimes are defined as a violation of Nebraska or federal law. Before the trial begins, the judge will inform you whether it is a civil or criminal matter. In a civil case, the judge will explain the nature of the case and identify the litigants that are involved. In a criminal case, the charges against the defendant will be described. Next is voir dire, which is when the judge and the attorneys are allowed to question prospective jurors. Jurors are required to truthfully answer all questions that they are asked. You have an obligation to share any concerns that you believe might affect your ability to be a fair and impartial juror. Without giving a reason, each attorney has the right to remove 3 prospective jurors in a civil case or 6 in a criminal case. A juror who knows one of the litigants, the witnesses, or the attorneys will most likely be excused. Remember, the judge and the attorneys are trying to find a fair and impartial jury. This means finding 12 jurors who can set aside their opinions and biases to decide the facts of the case based solely on the evidence presented. You should not be offended if you are not selected. If you serve as a juror, the court will provide you with a notepad and pen. At the conclusion of the trial, your notes will be destroyed. Once the trial begins, the attorneys will make opening statements, which are simply an overview of the case that each attorney expects to present. None of the statements of either attorney should be considered as evidence. Next is the presentation of evidence. The plaintiff or prosecutor goes first. Each side will call witnesses to testify, show documents, physical objects, or other items relevant to the case. Each attorney also has the right to cross-examine all witnesses. It is your job as a juror to determine the credibility of the witnesses. There are rules which govern what testimony or evidence jurors are allowed to see or hear. Either side may object to the testimony or evidence that it believes is outside those rules. When this occurs, the judge will rule on the objection and, if necessary, will call a sidebar so that a private discussion may occur between the judge and the attorneys. This private conversation is not meant to keep or hide something from the jury. Rather, it is done to make sure that the trial is being conducted fairly under the law. A real trial isn't always as sensational as it is in the movies. You will need to pay close attention to what goes on inside the courtroom. The judge will explain that it is your duty as a juror not to speak with anyone, including your family or friends, about the trial. Additionally, you'll be instructed not to engage on social media, read the newspaper, or do any independent investigation at home or in the courtroom. This also means that you should not visit the scene of the crime, an accident location, or attempt to talk to a witness. It can be tempting to search for information about the judge, attorneys, litigants, or witnesses involved. If you do this, you're violating court rules and depriving individuals of a fair trial. These guidelines are essential to providing a fair trial. That is because what you may see or hear outside the courtroom could be misleading and/or inaccurate, and neither the judge or the attorneys will be able to correct or refute it. After all the evidence is presented, the attorneys will give their closing argument, which is a summary of the case and each attorney's view of what the evidence and the testimony prove. The jury must fit the pieces of the puzzle together, knowing each side is painting a picture from their own perspective. After the attorneys have finished, the judge will give you detailed written instructions. The instructions will tell you how the law relates to this case, and you are required to follow them. Listen carefully as the judge tells you precisely what you have to decide. In a civil case, the plaintiff must prove his or her version of the facts is more likely true than not true. Additionally, you may also be required to decide what the plaintiff should receive, and the judge's instructions will help you do this. In a criminal case, you're asked to find the defendant guilty or not guilty. In our criminal justice system, all people are presumed innocent until proven guilty. The government is required to prove beyond a reasonable doubt that the defendant committed the crime. In order to find the defendant guilty, your verdict must be unanimous. Before you begin deliberation, the judge will provide the state of Nebraska's definition of reasonable doubt, and it is the definition you must follow. After receiving the judge's instructions, you will select a foreperson who will lead the group through the decision-making process. Once deliberations begin, you will have a copy of the jury instructions and the evidence in the jury room. You will not receive a transcript of the testimony. Therefore, you must rely on the collective memory of the 12 jurors and your notes. Differences of opinion are all part of the process, so if you disagree with another juror, please speak up. Remember to be civil when speaking with other jurors. Being attentive, considerate, and respectful to other jurors will help the jury as a group reach a sound and proper decision. Once you reach a verdict, you will return to the courtroom. However, if you deliberate and cannot reach a verdict, notify the court. When you, the juror, perform your duty objectively, you contribute to the fairest system of justice in the world. Remember, the United States Constitution mentions jury duty as both a right and responsibility of all Americans. We sincerely appreciate your time away from your family, job, and daily life to serve on this jury. Thank you.